welcome to Season 3, Episode 9 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. My name is Estefania Contreras. I'm part of ARBinBRIEF team and practice international arbitration with Baker McKenzie in Bogota. I will be moderating today's episode on type of remedies, what's new on ISDS, featuring Dyalá Jiménez, an international arbitrator at the 𝗔𝗥𝗕𝗙𝗥𝗕𝗙 in San Jose, Costa Rica, and Claudia Frutos-Peterson, the first woman managing partner at 𝗔𝗥𝗕𝗙𝗥𝗕𝗙𝗏 LLP in Washington, D.C. The roundtable discussion will address the types of remedies in ISDS, in particular restitution as a non-monetary remedy, and what the discussions around the ISDS reform are in type of remedies. Dyalá, hi. Can you explain restitution as a non-monetary remedy to us? What is it? Can it be ordered?
Hi, I'm delighted to be here in ARBinBRIEF. Thank you so much for inviting me, and I'm very honored and happy to share it with Claudia Frutos-Peterson. Restitution is a type of non-monetary remedy under international public law, and essentially it involves putting the situation back to the way it was before the wrongful act. It can entail restitution of property, but it is not limited to only that. Now, you asked, is this available under ISDS? And essentially, people have identified two main obstacles for this kind of remedy in ISDS. The first is that an order for restitution usually will entail ordering a state to do or to refrain from doing something that depends on acts that fall within its sovereign power. So if you read AMCO v. Indonesia, the tribunal there stated, it is obvious that this tribunal cannot substitute itself for the Indonesian government, and some national courts have agreed with this position. However, on the other hand, some commentators believe that this is ill-conceived and that if international public law provides for restitution, that argument of state sovereignty should not interfere at all. In any case, there is another obstacle for this, and it deals with the ICSID Convention. The Washington Convention, as we know it, speaks only of a state having to enforce pecuniary obligations in Article 54. And so this has been interpreted by many that awards cannot include non-pecuniary orders. But if you see cases such as ATA versus Jordan, there the tribunal ordered that local court proceedings be seized or terminated unconditionally. In that case, it was peculiar because it wasn't a restitution case, strictly speaking. What the tribunal ordered had to do with the underlying rights that it was enforcing. But it does show that there are non-pecuniary awards under ICSID. The question is whether they're enforced. And finally, if you have a non-ICSID case, the tribunal will still need to look at the underlying treaty because some treaties exclude remedy of restitution, such as the NAFTA and the following USMCA. On the other hand, the ECT appears to validate non-pecuniary remedies, so you have to really look at the underlying treaty as a tribunal. And finally, the starting point of any tribunal in any case will be the specific request made by the investor. So you first start from that and then go on to see whether you can or cannot issue a remedy such as that one.
Thank you, Dyalá. Claudia, do you have a comment on that?
Thank you, Estefania. First of all, thank you to ARBinBRIEF for having me today. It's really a pleasure to be here and especially sharing this discussion with Dyalá. It's an interesting topic and a pleasure to be with all of you today. But the subject of restitution, of course, is very interesting because when you think about ISDS, you don't really necessarily see a lot of decisions that deal with the restitution as a concept of compensatory, means in awards. And maybe because, most of the ISDS cases, as we know them, they are administered by ICSID. I mean, UNCTAD tells us in 2023 that 70% of those cases, they were administered by ICSID. So, and as Dyalá just explained, the ICSID Convention talks exclusively about pecuniary remedies. Probably that is the reason why we don't see a lot of awards dealing with restitution, at least not in ICSID arbitration cases. It's also interesting, as Dyalá was also explaining, a lot of the treaties, especially the treaties under the new wave of free trade agreements treaties, I'm mainly thinking about those, they do not deal with the question of restitution, despite the fact that it's also recognized as a compensatory remedy under international law. And they still talking about pecuniary compensation, I'm sorry. So, some of the treaties, they even will go and prohibit restitution, and probably the field in which we see more restitution as a remedy is going to be international commercial arbitration. I know that Dyalá mentioned the ATA case versus Jordan, but, not to be disappointing anybody, but I'm wondering, whether that award will really going to be enforceable. I mean, first of all, there was an annulment request by Jordan at the time, and that annulment committee could not render its decision because the parties settled. So I'm not saying that I'm not a believer that in an ICSID case we could have restitution as a remedy, but I haven't seen it as such so far. At least, the question of enforceability is going to be a big one in ICSID arbitration.
Thank you, Claudia. And on that, Dyalá, as an arbitrator, when, if ever, do you think it is appropriate to grant this type of remedy in a case? Can you give us an example?
That's a good question, because what would happen if you're sitting as an arbitrator in an ICSID case and the party asks for either a restitution or non-pecuniary remedy or any other remedy as the tribunal may deem appropriate? So you have a tension between Article 48.3 of the Convention that says that the award shall deal with every question submitted to the tribunal, and then Article 54.1. If the tribunal is convinced by the parties' arguments that restitution is something that it should be granted, what do you do? Or if sua sponte, the tribunal wants to ask the parties to comment on what does any other remedy deemed appropriate by the tribunal, can it under the ICSID Convention? So these are the questions that one needs to ask oneself, even if I have not been come across to that. And you see another case that is interesting is ARBINBRIEF versus Moldova, where what the tribunal did was a sequential order against the state. So first, they deemed that the best solution was to order the state to restitute or give back the licenses of duty-free stores, plus some part of compensation within a timeline. I think it was 90 days. And within the same dispositif, what they said is, if the state does not do so within that time, the state will be ordered to pay a larger monetary compensation. So this is a sequential two-step order, and I thought that was interesting. So, I wonder whether investment treaties will include that increasingly or not. The paradox is that at times, I think maybe even for the state, this might be more convenient if you have a long-standing relationship that you want to preserve, and it is less costly than paying damages. So maybe it would be better for that to exist more broadly, although the sovereignty question does arise. So these are the tensions I think arbitrators have to ask themselves.
Thank you, Dyalá. Claudia, for the second part of the episode, what are the discussions around the ISDS reform in the type of remedies?
Well, as I'm sure that everybody attending this discussion knows that UNCITRAL has been dealing for the past 6 years, with analyzing the different issues, that the community is having concern regarding ISDS cases. When it comes to damages or remedies, for damages, the big topic, of course, is the exorbitant awards. So the mandate that UNCITRAL received originally was, of course, deal with with procedural issues in ISDS. And that has been the main discussion by UNCITRAL. Having said that, in recent years, some of the member states, they have been pushing to add the question of remedies, the question of damages, quantum in ISDS. And I don't blame them. The awards that you see out there, they are exorbitant. And I think there is no uniformity, in the way that most of the arbitral tribunals decide this type of cases. And I think that's the main reason why UNCITRAL is going to be dealing with the question, not necessarily, as a substantive topic, but it is connected to some procedural aspects of ISDS in order to try to have more consistent and uniform decisions. So if you look at the draft article that UNCITRAL has put out there for discussion, so that particular provision is provision 23. They have a first draft, but it hasn't really been discussed yet. The expectation is to have some time to discuss it this fall or probably next spring in 2025. And when you look at that article, when you look at that provision, you notice that there is the reference, to the monetary damages, and it also talks about restitution of property. And of course, my first reaction when I saw the provision is, of course, because it's a principle of, the recognition of restitution as a principle of international law is there. But when you look into details at the draft that they are proposing, it does mention the opportunity to, the fact that the tribunal shall have to provide that the respondent can pay monetary damages representing the fair market value of the property at the time that it has been expropriated, or at the time when, expropriation has become known. So as you can tell, even despite the fact that we are talking about restitution of the property as part of the draft article, it comes back again to monetary damages. So I really, don't know if we're really be talking about restitution of property, in ISDS, even despite the fact of having it in this draft article at the end of the day.
Thank you, Claudia. And Dyalá, do you have a comment on that?
Well, yes, again, we go to obstacles because I think Claudia rightly mentioned you go back to monetary relief in part because of the practical consequences. When there is a taking, often it is, for some to do something with that property, and that something has been done during the time the arbitration ensued. And so how can you return a property upon which the state has already acted? Even practically, not only as a matter of principle, it is difficult to have restitution in the terms of the proprietary restitution, not necessarily on the status quo ex ante. It really is a case-by-case scenario. In any case, I think that this working group is important. We need to look out for all the things that will emerge from that, the compensation standards, the circumstances that need to be taken into account, even causation, which is so important, and evidentiary requirements. I think this is a very complete work that the working group is doing. And I just observe that their emphasis is on, or the frustration, if I say, is on the lack of correctness, consistency, and predictability of awards. So I wonder if we're very frustrated with the human errors and whether, intelligence, artificial intelligence will help in that way, or whether there is no such thing as a correct award. So I end with this philosophical question.
Yeah, if I may just add very quickly, Estefania, I mean, I agree with Dyalás comments, but to me, the most difficult discussion that the working group is going to be having, in connection with damages, is really the valuation method. What really what do the states they want to achieve in order to really give guidance on how to apply a methodology, how to evaluate that methodology, in order to evaluate the damages. And unfortunately, I don't see a lot of, at least not in the provision as it is right now, going into that direction. Of course, the provision is good; it's a good step, but I think it is going to need a lot of discussions, on the part of the state members and the community. Thank you.
Thank you very much, Dyalá and Claudia, for this incredible, insightful discussion. We would like to thank our partner organizations on Equal Representation in Arbitration Pledge and the Lagos Chamber of Commerce International Arbitration Center for their support in making Season 3 possible. We are also truly grateful to the many organizations that support the marketing of our series around the world. For those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos on hand-picked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback, and you can register for our next episode on arbitrators.com. We look forward to seeing you there. For those joining us live, we will now have a chance to pose a couple of questions to Dyalá and Claudia in a more interactive way. To join the Q&A, you will need to join a new Zoom webinar using the link just posted in the chat box. See you there.